So, Peter, thanks very much for the introduction and giving me an opportunity to do this webinar with four friends. Three are old friends. Not that they're old. I'm the only old person in age. It's just that they've been friends for a long time. And I have a new friend, and that's Amanda, and I'll introduce all of them in a moment. The purpose of this webinar is to inform our audience about the SEC climate disclosure rule. I'm sure they've been following this. A lot has happened. A lot of other things have happened kind of more generally in terms of decisions by the Supreme Court, which may have an effect upon the authority of the SEC, and we'll dig into that as well. But we'll start with climate, and then we'll get more broadly. Before we jump in, I'd like to introduce my panelists, all lawyers. As I said, I'm not a lawyer, so I'm a little intimidated being here with them. I'm sure I'll learn a lot. I'd like to start with my good friend Allison Heron-Lee. She was an SEC commissioner. She was acting chair, and she really led the charge on framing the climate disclosure rule. So I think hearing from her will be very useful. And then after we hear from her about the rule, the history of it, and kind of where it stands today, I'm going to get my good friend Tim Doyle, who is the president of the Responsible Business Initiative. And in full disclosure, he and I started this together. But don't worry, I'm not going to cut him any slack. I'm a Democrat. He's a Republican, so he gets no favors from me in this conversation, just to be clear. And then after Tim has given us an update on where the litigation stands and where it might go and kind of some thinking about the timing of the decision, I'm going to ask my friend Betty Huber, who is the co-head of ESG at Latham and Watkins, what's going on with her clientele in the corporate community, the investment community. You've got the SEC disclosure rule, which has been staged. You've got the ISSB, you've got the CSRD. So companies and investors are in a period, I think, of uncertainty and conflicting pressures. Betty will give us an update on that. And then I'd like to go to my new young friend, Amanda Rose, who is on the Academic Advisory Board, I'm pleased to say, of the Responsible Business Initiative, who's a law professor at Vanderbilt. I'd like her to kind of step back and reflect on just how big of a deal is it, what's going on with this SEC disclosure rule, and how big of a deal is it, we'll ask her later on, in terms of these other decisions that have made by the Supreme Court, and kind of how we think about the authority of this agency going forward, what that means for future rules on disclosure that they could issue or not, and then related issues more generally. So with that, Allison, let me turn it over to you. If you could give us a history of how this rule came about and where it stands today, I'd really appreciate it.
Sure. Thanks, Bob. It's a pleasure to be here and to be an old friend in both senses of that word. So I'll start with, in 2021, I became the acting chair in January of 2021 at the SEC. And one of the first things I did was take a look at and assess the situation with respect to sustainability, but more specifically climate change risk in capital markets, how much transparency, how much accountability there was. There was a lot of pent-up demand. So I issued a request for public comment even prior to the SEC issuing a rule proposal, which is, of course, more than what the APA requires, but I felt like the complexity of the subject warranted that. So in March of 2021, I issued a request for public comment on whether, and if so, how, the SEC might enter this space and think about adding disclosure obligations and getting more transparency around climate change risk. We then, as you know, a year later, in March of 2022, the SEC issued a rule proposal. Then, now I will tell you, we got thousands of comments from the initial request. We got thousands more comments once we put the rule proposal out in March of 2022. I won't go into what that proposal said, but suffice it to say, it was there was a lot more in the proposal than what made its way into the final rule. The final rule was issued in March of 2024. And largely speaking, I'll tell you, it contains kind of 5 elements. So it has, and it's based off of and leverages a lot of the work that's been done through private ordering at TCFD and the GHG protocol. So it includes provisions regarding risk, governance, and strategy, just like you see in the TCFD. It also and all of this, almost everything in the final rule has a materiality qualifier, meaning management will have to look at it, decide if it's material or not, and if so, make certain types of disclosures. So you have risk, governance, strategy. Then you have the scope 1 and 2 greenhouse gas emissions only if material, nothing on scope 3 that got removed from the final rule. There are folks who are of the opinion that scope 3 could find its way in through other channels. I won't go into those nuances right now, but I'll just tell you the final rule: scope 1 and 2 greenhouse gas emissions if material. And then finally, a piece that would disaggregate certain types of climate impacts from the financial statements. So a piece in Reg SX that would be a footnote to the financial statements that would disaggregate impacts from severe weather events, largely speaking. So that's kind of the 5-point framework for the final rule issued in March of 2024. To no one's surprise, I think the litigation was filed either that day or the next day in various circuits that got consolidated into the 8th Circuit. And that's where we are today, defending that. And by we, I mean they, the SEC is today defending that litigation.
So that's helpful. Let me couple of quick questions before I go to Tim. I mean, I guess you guys probably assumed there was going to be litigation, right? I mean, this is America.
Sure. I think from the start, everyone understood it was likely. I will say that I believe there might have been some disappointment given how far back I think they pulled from the final rule or from the proposed rule, that there was still as much sort of objection as what we found or what they found. I was gone just for full disclosure. I wasn't there to vote on the final rule. I stepped down. My term ended in 2022. But yeah, I think they always knew there would be some litigation, but I do think I was a bit surprised that that some folks weren't more satisfied with the changes that were made, because they did pull back pretty drastically from the proposal.
Well, and it's interesting, and we'll get into this again with Tim. The litigation came from really both the left and the right, and there's some ironies in that, I think, which we can talk about. Last question before Tim. So at least with large companies, I mean, the things that you talked about, TCFD, Greenhouse Gas Protocol, at least my impression is that the large companies have been more or less, many of them kind of following these general principles for a while, right?
Yeah, there are a number of large companies in the S&P 500 and broader that have been making similar disclosures. I think the SEC's final rule tried to do a tally of that and lay out kind of the lay of the land, who's actually already doing this kind of disclosure on voluntary basis. So yes.
So then there's the question of, if for the big companies, and then Betty will talk about kind of other reporting requirements, like how heavy a lift as it is. But I also know there was some controversy around what this meant for, the smaller listed companies. And then you and I have talked about what this means for private companies, because they're not covered, and obviously, the private companies are an increasing proportion of the marketplace, which is another kind of controversy to talk about. So listen, thanks for the update and kind of the lay of the land now. So we finally got a rule. It was pared back quite a lot. And then the litigation began. So Tim, where does all this stand, all this litigation? Who's suing who and for what? And who's going to decide? And what's all this entertainment about?
Well, yeah, and thank you for having me, Bob. It's I'm glad also to be known as one of your old friends and now a partner, so to speak. I think it's to go back to one of your questions about whether they anticipated litigation. It was interesting. I was at the U.S. Chamber of Commerce is probably the lead petitioner here that filed suit. Many of whose members, Betty probably represents. So there's a kind of a weird connection in that sense. But just before the rule was finalized, the chair of the SEC, Gary Gensler, came and spoke to the U.S. Chamber of Commerce here in Washington, D.C. And there was just open discussion about the litigation and whether it could be either pared back or maybe even not happen at all. And I think to Allison's point, there was some optimism for those supporting the rule that when they scaled back the Scope 3 aspect from the proposed to the final rule, that was going to be sufficient to stop the litigation from going forward, or at least not make it such a big issue. For those of us that had questioned some of the rule making and the final rule, Bob, as you and I have talked about, there are things other than Scope 3 that certainly are the basis for what the Chamber of Commerce was arguing. So it was, as Allison said, it was consolidated. Now it's with the Eighth Circuit. Interestingly, it's considered a relatively conservative circuit in the Midwest states, if you will. They are notoriously slow, so I hope I don't get in trouble for saying that. But nonetheless, it is now with them, again, consolidated cases. I think there are 46 states now have some way weighed in on this case. So it's certainly, not to preempt our discussion later, it's certainly a major question that is being determined. Briefs for this are now in. They were filed in August and September. We anticipate oral arguments in October and November. And this is where I think it gets really interesting, because a lot of people were hoping that this would be resolved before the presidential election. And that obviously is not going to be the case. I think at the earliest we would get a decision out of the Eighth Circuit would be somewhere early in 2025. So that's probably the background on it right now. There are other things that are going on, and we will get to those. The litigation regarding the California disclosure rules that we'll talk about are moving parallel to this in the Eighth Circuit. So it'll be really interesting to see timing wise when this all shakes up and who goes first. Does the Eighth Circuit go, or is this appealed to the Ninth Circuit out in California? So with that, that's probably the best update I can give you, because we just don't know yet.
Let me ask you a couple of questions about the litigation. Does somebody want to jump in, Allison? Does somebody else want to jump in on the litigation, since you're lawyers? So here's what I'm trying to understand, Tim. So we know people at the Chamber, they're nice people. We have breakfast with them. One of them is a Republican that has avocado toast for breakfast, which always impresses me that a Republican is having avocado toast instead of bacon and eggs and waffles and sausages and kind of stuff you'd have if you're...
Tom Quadman's a healthy guy.
Yeah, Tom Quadman's a healthy guy. I'm not sure he wants people to know he eats avocado toast, but it's too late. It's out there in the public domain now. I'm trying to understand, what's going on with the Chamber, right? I mean, is this kind of just a knee-jerk reaction lawsuit as part of these ESG culture wars? Is it, there's really substantive reasons that they don't like the rule? I mean, Allison said, look, there's materiality requirements. Scope 3 is gone. Even Scope 1 and 2 is material. So I'm trying to understand what the motivation is and what's kind of driving this lawsuit. And it's them and red state attorney generals. But in fairness, the left is suing as well. You've got NRDC and you've got the Sierra Club, and they're all aggravated that Scope 3 went out. So they're mad at the SEC because they didn't do enough. The Chamber and these red state attorney generals are mad because they did something they don't think they should be doing. Help me understand what's behind these lawsuits.
Sure. Well, there are a couple of different claims in the lawsuit. There's First Amendment claims, compelling speech, essentially, of these companies. I think the biggest one, and we'll get into this in a minute when we discuss Chevron and major questions doctrine, but there are the Chamber and others. One of their main arguments is that the SEC is essentially out of their lane, that this is beyond the scope of what Congress ever intended them to do. Now, that's of course arguable, as Allison, I'm sure, will love to pipe in and say, no, they're well within it. And so I think one thing to keep in mind, and again, I do have to remind my friends on the right, this is that climate disclosure has been required at the SEC before this rule. We have 2010 guidance that has been complied with. So it's not that if this rule goes away, that all of a sudden climate disclosure is not going to be materially relevant and has to be disclosed. But I think that the purpose, and I'll defer to Allison, that I think that the purpose was to really make sure that the type of information that they were getting was clear and consistent and comparable. And so there's a lot to be said for that argument for the rule, or as I argued from the beginning, a clarification of the guidance 2010 guidance document probably would have accomplished that. But so those are kind of the major issues that the Chamber at this point is arguing against the rule. And Amanda, I don't know if you want to weigh in. I know I'm probably missing a couple. So I think there's 3 or 4 of challenges, but those are the 2 big ones for sure.
Well, why don't we stay on this? Anybody else that wants to jump in before we talk about Amanda?
I mean,
Go
I
ahead,
would
John.
just say, and I don't know what is motivating the chamber, but I would say that there are a lot of costs associated with complying with the rule. I think the final rule is um, much better than the proposed rule on that front. And the addition of the materiality qualifiers, which we can talk more about, I think strengthens the SEC's position considerably in the litigation. But determining whether or not things are material at the company level itself costs quite a bit of corporate resources. So I think that's certainly, it's not hard to understand why there would be pushback from the business community.
I mean, I think that's fair. And the chamber represents, they're not the business roundtable. I mean, it's kind of like the whole business community, the BRTs, the big companies. And so these constraints around capacity and cost or something will be felt more, I think, in the kind of the mid-cap market. Allison, anything else you want to add, both the lawsuits from, the chamber and the red state attorney generals, as well as the Sierra Club and the NRDC? Anything you want to add on the litigation?
So Sierra Club and NRDC dropped their challenge, as you may know, and they, but they're, I think potentially they're quite interested in the outcome, and people have been working on amicus briefs and the like to try to support the rule. But I want to say one thing to Amanda's point about materiality qualifiers. It absolutely does cost a fair amount to do a materiality analysis, depending on the type that you're doing and the like. And that's not without ramifications. But of course, one of the issues I think the SEC and I certainly have struggled with over time is there is a strong push to do this principles-based approach where you say essentially just decide whether this is material to your business and do. And that is strong support amongst folks like the Chamber of Commerce versus a more prescriptive rules-based regime that says just disclose these items. I think a lot of money can be saved when we do that. When the SEC simply says, here's what you should disclose. That actually can reduce the cost quite a bit because you don't have to engage in the question of how material is this to my specific business and business model. So there's tension there in finding the right mix between saying just disclose it if it's material. That can overlay a fair amount of costs, or here are the things we'd like to see, like we did with, for example, with executive comp. So I think, and the SEC takes quite seriously its obligation to weigh those costs. Another problem I'll put in here is it's very hard to put a dollar figure on benefits. So I feel like there are many ways in which that formula is kind of self-perpetuating and kind of invites an answer that the costs are always going to seem high, because you cannot put dollar figures on the benefits. Now, what the SEC did, of course, here, we had the California rule come out. We have all of the voluntary. So what they had to do was essentially say, how much incrementally is this going to add to what people are already either doing voluntarily or required to do? And I think that also went a long way toward curbing some of the costs. But again, the cost piece of it is extremely important, and always the SEC has to pay, a fair amount of focus and attention to that. The three big challenges, and Tim, I think you may have hit on these, are First Amendment cost-benefit analysis and major questions doctrine. That's kind of the big picture of the landscape of how the rule is being challenged. And I think of those three, possibly, it's no surprise, I think MQD is probably the biggest threat, but I worry the most about First Amendment because of the implications that First Amendment ruling would have for the SEC's mission going forward.
So the cost benefit is interesting because there's really an asymmetry. I mean, the SEC, part of its mission is to protect investors through transparency. So the costs are being kind of paid for by the companies, ultimately borne by their investors. And so there's investor benefits, which are really, really hard to quantify versus the costs. It's the same thing with audits, right? People have that argument about audits. Before we get to Betty, but real quick, I mean, what do you think of this notion if it was prescriptive and it's like really clear and you don't have to do the materiality analysis, everybody knows the rules of the game? Does that sound good to you or not? To say, here's the rule, just everybody do it.
I think
To
it's...
me, I'm sorry.
Yeah, who are you asking, Bob?
Amanda, I'm asking the professor, someone that knows things, the professor. Although, in fairness, Allison is a professor now at NYU. I should have said that. She's at NYU Law School. So, Amanda, please.
I think that the balance between sort of rules and standards is a difficult one throughout the law. And I think it very much depends on the specifics of what we're talking about. If it is a prescriptive obligation to disclose something that's easy for companies to produce, versus something else. So it really depends on the details and what specifically, what piece of information we're talking about. But that's something that the SEC has to confront in every rulemaking. And different people have view the trade-offs differently, which are, difficult to quantify. And people have different intuitions about, for example, how those two approaches play into liability risk and other things. So it's a difficult question, but a really important one that you raise.
And just one more question, and then I am going to go to Betty. So this First Amendment thing, when I first heard that and the Chamber wrote about it, I'm thinking, look, I just don't get it. I thought the First Amendment was freedom of speech or something, so that I can go out and say stuff, and even if it's stupid, nobody can get mad at me. But now there's this compelled speech thing in the First Amendment. So for the non-lawyers in the audience, maybe Amanda, like, what is this compelled speech thing? Because I didn't get it at all when I first heard about it.
Well, with the caveat that I'm not a First Amendment scholar, I will say that it's not something new. The First Amendment protects against government sanctioning you for your speech, and also for forcing you to speak on topics as well. And that's been part of the First Amendment for a long time. There's a very important carve out for quote commercial speech, which is where sort of the SEC sits, where you get more deference for government regulation when it serves certain purposes. And the argument that's been raised is that this doesn't qualify for the kind of deferential treatment and requires sort of strict scrutiny because it touches on matters of controversy or non-factual matters, which the government has to satisfy a higher burden to compel that sort of speech. It's interesting to me that the SEC has, for a long time, sort of been sort of dodged First Amendment challenges, but it is sort of the biggest speech regulator, in the United States, and there are some important questions that I think we would benefit from clarification on.
That's really helpful.
Now, of course, the SEC's position is that this isn't something different. This is, financially material information that is factual in nature. So it really depends on how you kind of characterize what the SEC is doing here. I personally think that the cost benefit, we'll get into this as we talk more about sort of the fate of the litigation. My 2 cents, if I'm reading the tea leaves, is that the rule is likely to fail on cost benefit grounds rather than on major questions or First Amendment grounds.
Oh, that's interesting. Which kind of does nicely get us. So, Betty, out there in the world, companies and investors and litigation and uncertainty, like, what are people doing? What are people thinking? What's it like out there?
Yeah, well, all of our clients, from small to mid to large cap, I think you're right to say that all of them approach this very differently. So 6 months ago, when the rule was finalized in March, many of our clients, the large ones, were said, okay, let's take a look at this. Let us figure out what is material and how we need to comply. And many of them started mobilizing very large efforts to take a look at the rule, do a gap analysis as compared to what the company was already disclosing according to voluntary reporting, whether it's in their GRI, CDP, et cetera reports, as well as in their 10K, to say, all right, what's that gap analysis? And then second part, doing basically an MD&A style analysis of what is material and what from those voluntary disclosures need to actually show up in our 10K. So we had many different clients reach out to us to go through that exercise, which would be painstaking and which would require interaction with not just the legal departments of clients, but also the accountants. And I know that a lot of accountants are on the line listening and trying to understand, what does this mean for me? And what it means for them is that, as Allison nicely said, the rule would require, some limited assurance and eventually reasonable assurance. That's kind of where this is all going. There's so much disclosure out there, and trying to make sure that that disclosure is reliable and decision useful is really where I guess all the regulators sort of agree upon. As soon as the rule was stayed, then pretty much people put that exercise on hold. And then what does that mean? So, now that we're in September and 10K season is upon us, there are many companies, large ones that have securities listed in Europe that have been looking for at least a year and a half now to the European Union Corporate Sustainability Reporting Directive, which people call CSRD. I'll try not to use too many acronyms, but it's a bit of a mouthful to say the whole thing all the time. So you have some of the biggest banks, some of the biggest insurance companies, and then other companies that have securities listed in Europe looking and having to actually disclose against CSRD in 2025 off of 2024 data. So back already in 2023, we've been advising clients to figure out, what does this mean? And under CSRD, there is a different definition of materiality. So Amanda, Allison, and Tim have all talked about materiality, and that seems to be a really important point here. So if you think about a company that files a 10K, that is also subject to CSRD, and that report is due by April of next year. So if I can do math, 7 months from now, this is quite an interesting challenge, since their 10K will be due in 5 months from now. So right now, that is the real question for me. Big companies having to disclose against this, and it's under the standard called double materiality. So it's financial materiality. So, what is the financial effect of, sort of sustainability issues, but also what is the company's impact on the environment, on people, and on their workforce? And so the SEC rule focuses only on climate, but CSRD covers 12 different sustainability topics, from climate to biodiversity to pollution. And then on the S of ESG, it would be your own workforce, workers in your supply chain, affected communities, communities affected by your business, and under the G of ESG, business ethics. So it wraps up so many different things. And that's really what we're focusing on right now, our clients. In addition, I think California was discussed. California also has a series of 3 different rules passed last October by California Governor Newsom. Our clients are looking actively to try to figure out what they need to do there and by when. So it's not even just a materiality question of what needs to be disclosed, what kind of rigor that disclosure needs to be, subject to, what kind of auditing comes out of that, but also the timing of it. So the timing is all kind of messed up, if that's a legal term of art. But with this litigation that everyone's been describing, even if the rule, the SEC rule, kind of survives in some shape or fashion, presumably, and maybe it'd be interesting to hear Allison's view on this, that the compliance dates set forth in the final rule of March be pushed out. Certainly, a lot of our clients are angling towards that, and to the extent that they have the ear of the SEC, would probably be requesting that to say, give us some relief so that we can figure out, so that we don't need to be disclosing against some rule with very limited lead time when we're already subject to CSRD. We're already subject to the California rules, which, as written right now, and also subject to litigation, would require disclosure in 2026. There's some nuances to all of that I won't get into now, but really the point of me saying this is that there's a series of different and disparate disclosure requirements that companies are subject to, trying to figure out the morass, but also hoping for some interoperability between all of those things. Maybe one thing that I'll say, to give a live example, and Bob, you can cut me off at any time, but like to give a real example of how complex this is, as opposed to just kind of talking about it. Under CSRD, there's a requirement under, there are these European sustainability reporting directives, which can implement CSRD. And there's a requirement to disclose, if material, doubly material, current financial effects. And taking a look at that, what does that mean? A lot of companies are struggling with this now because under double materiality, maybe there could be certain impact material items that could have a current financial effect on a company. But at the same time, this company has a financial statement. Current, it's probably 1 year. They're not disclosing this in their financial statement. So what does that look like if something new is disclosed under a CSRD report that is not showing up in a financial statement? This is the world of auditors, that they need to be focused on this and making sure they're keeping an eye out on all of these qualitative disclosures that are coming out under the guise of impact materiality and CSRD, and making sure that the financial statements are right and can withstand audit.
So I've got a couple follow-on questions. Do you want to talk about the ISSB first before I ask you questions? Talk about the ISSB.
Yeah, so Bob and I met through SASB, which is sort of, related to ISSB. So I guess I didn't want to lead with the area that we're slightly affiliated with and have an affinity for. Yeah, so the International Sustainability Standards Board, ISSB, has put out some disclosure frameworks, one on general sustainability and one on climate. So maybe just sticking to climate, since that's really the focus here. These frameworks are voluntary. Of course, this is a voluntary organization, but many countries around the world have signaled that they'll adopt ISSB as law. So that adds to, so the downside is it adds to the fragmentation of all the different laws that we've just been discussing. So the UK, Japan, Brazil, Singapore, some other countries have signaled, and Canada as well, Australia, adopting in some form or fashion the ISSB standards. And so think about that. If you're a multinational corporation with operations in the US, the EU, all of those countries I just listed, what do you do about that, right? So ISSB will say that materiality is kind of SEC, financial materiality. Things get a little blurry. I'll leave it there, but really focused on the ISSB. And I think they have been really trying hard to deal with that interoperability and the kind of fragmentation question. And in a perfect world, really with this very noble goal of coming up with like a global baseline of disclosure. Unclear what will happen in that regard, but they're working very hard on that, Bob.
Well, the global baseline is important because investors don't want to have different ways that companies are reporting, and companies would just like to have one. And it's even more complicated, right? Because you've got the California laws, you've got ISSB, you've got the CSRD, you've got the SEC rule, and you've got the Global Reporting Initiative, which has been about impact materiality since 1997. So you've gone from this collection of NGOs of an alphabet soup now to regulation. To size the CSRD, and again, I'm sure people know this, covers 50,000 companies. And I look at it and I'm thinking, it's a pretty low bar, 150 million euros in revenues, in Europe. And I think it's $1 billion, and you're doing enough business in California. So I forget the count, but there's going to be a large number of U.S. companies, and it's a law, it's a directive in the EU you're going to have to report. And it has scope 3 in the climate, and ISB has scope 3. So I guess the question is, at least for these companies, since they have to do this, and it's a whole lot more than what the SEC is asking for, how much does it matter to them what finally happens with the SEC? And I guess it goes back to, when they have to, if the rule is released. So could you help us understand, in the context of all these things, companies already are going to have to do, the big ones, how do we think about the state of the SEC rule in that larger context? And start with you, Betty, and let everybody else jump in.
Yeah, well, I guess, companies are pragmatists and they focus and expend resources on what they need to do. And if companies are required to make this disclosure under CSRD as a pure compliance matter, they're complying. And at the same time, you're right, though, what does that mean for the SEC rule? So I can imagine a world where the first companies in the first wave, those lucky companies that need to disclose in 2025 off of 2024 data, will probably want to be able to be living in a world where at least maybe the SEC would recognize and perhaps say, okay, you've complied with this, perhaps that could count towards disclosures required under securities laws. I know that is, a complicated thing to say and maybe controversial, but that would be helpful, right? And I definitely wrote some comment letters for some foreign private issuers back when the SEC had proposed the rule. So I can't even remember at this point when it was, but they were like, we're subject to home country rules in Germany, which are way more onerous than what the proposed rule is requiring. Please, can you recognize this? And so that's kind of the similar thought process. And you're right, investors, it's probably going to be frustrating if they're reviewing one CSRD report, which is in the management report of the Luxembourg entity of XYZ, and then XYZ's 10K has something else, as well as the CDP report, as well as the GRI report. We're getting questions right now. The CDP deadline is fast approaching, and if things go into that report that don't show up in the CSRD report, what does that look like? What kind of world do you live in? What kind of disclaimers can you put in the various reports to say, these are very different frameworks. They're not meant to read to one another. And if we have or don't have something in our CDP report, that should not have any bearing as to what is material in other mandatory filings. So this interesting world we live in, like the convergence of to use Allison's word, private ordering and all of those, reports, and then now kind of crashing into and possibly clashing with what's in mandatory filings.
Allison, do you want to comment? And I'll give Tim and Amanda a chance, and then we're going to go to the major questions doctrine. But
Sure.
first, with this, Allison.
Yeah, sure. So the interoperability question is extremely important, Betty. I know you know that firsthand from the work that you're doing. I have always been a strong believer and supporter in working hard toward that. And when we talk about a global baseline, I always think it's helpful to think of it as not a buffet, but a baseline. Right. And that's not where we ended up, frankly, unfortunately, over time. Here's the one thing, though, that I take heart from. And you may have noticed this at the final rule when the commissioners gave their statements. 2 commissioners, one from each side of the aisle, spoke in support of potentially, at least with respect to ISSB. Now, I can't remember the details of Commissioner Ueda's statement, but he said something like that. I know Commissioner Crenshaw said something that they were disappointed and or would support going forward some notion of an equivalency or substitute compliance from if you're reporting with ISSB. So that doesn't really answer the CSRD, but it seems to me a similar dynamic would and should apply, especially if those disclosures are stronger than what the SEC has proposed. So I think, again, we'll see what happens. We'll see what happens with the SEC rule. But on a going forward basis, I think there's reason for optimism. I think the real key is going to be potential negotiations between ISSB and CSRD, because that's where you have the biggest gap of how to comply. So I would love to see those 2 organizations get a better handle on how to meld the potential requirements. And then I would love to see the SEC allow for some type of substituted compliance if you are reporting to that regime. And I think there's reason to hope that there could be.
So we're kind of good and out of time. I'm going to go ahead and we'll just jump to the major questions doctrine. So I heard about this, maybe a year or 2 ago. Still trying to understand it. My impression of the major questions doctrine is that the left says, thanks to the major questions doctrine and SCOTUS, the world is going to be a more polluted place and a less safe place. And, it's like, all is ill, right? We're facing doom and gloom. And the right says, thank God for the major questions doctrine. We're finally going to eviscerate the administrative state. And we've got these agencies that are going hog wild, going outside of the boundaries of what they should do. Beats me, right? I'm not a lawyer. So maybe start with Amanda, what is this major questions doctrine? And then we'll talk about what its relevance is to the SEC. But just tell us what it is, because most of our audience isn't going to know any more about it than I do.
Well, I think we're still kind of figuring out what it means. Before the Supreme Court recently overturned Chevron, it was sometimes characterized as an exception to the Chevron doctrine. But I think it continues to live post-Chevron as a principle of statutory interpretation. When there is a statute and the question is whether or not the agency has interpreted its authority correctly or not, the major questions doctrine essentially instructs courts to say, well, if the agency is asserting authority to resolve issues of major political or economic significance, we're going to require a clear statement from Congress. And if the statute doesn't clearly give the agency that authority, then we're going to basically assume that they don't have it. So it's a principle of statutory construction, which does limit, as a practical matter, agency discretion to sort of expand its authority or interpret it.
Tim, you want to add to that? Because we talked about this semantic.
Well, yeah, I know that you, Bob, we talked about how does the major question doctrine interact with the Chevron deference that Amanda was kind of talking to. And a lot of people have looked at the analysis in 3 steps. For the longest time, it was step 1 and step 2 that Amanda just talked about, which is the courts will first determine whether the statute was clear. And if it was clear, then they interpret the statute. If it was ambiguous, and this is then step 2, if it was ambiguous, if the statute was ambiguous and the agency gave a reasonable explanation for why it did what it did, the courts would defer to them. Well, so That's step one and step two of Chevron. Now, as we just talked about, Chevron, for all practical purposes, has been we'll call it scaled back, if not completely gone. As I mentioned, there's 3 steps though. So a lot of people looked at what they call step 0, which is the analysis that you would do before a Chevron, is where this major questions doctrine has now kind of placed itself. And that is to make the determination about whether the issue in which the agency was had acted upon was one of major political or significant economic significance. And if it was, and the statute wasn't clear, then the courts, at least under the major question doctrine, as Allison said, I think MQD, and I haven't heard the acronym be used, but I like it, so I'm going to start using it. MQD. Then they would say that you're outside of your lane, as I said earlier, and that's where this major question doctrine actually comes into the Chevron. So then the question is, what does that mean for the SEC rule? And we certainly can talk about that, but under what it means for just the Chevron analysis or agency analysis, as the court has said in the Loper-Bright case, which is the recent case that undid the Chevron, they really argued that with the removal of the deference to the agency, what they're really saying is that the agency's interpretation, their fact, the establishment of fact, the procedural process, were all still considered by the court. They just weren't given an overall deference. But they still would do that, and we refer to that as back to the original case from the 40s, which is Skidmore. And so going forward, that's really what the courts are going to have to do. So those are my friends that were so excited that Chevron on the right, that Chevron was over. I kind of have to remind them that, yeah, but judges and federal courts are still going to be interpreting and use as persuasive evidence what the agencies do, the reasonableness of what they've done, in addition to the other issues I indicated. So I think what the court was saying with the decision really was that we want this decision to come back to the judicial branch, where it should in their minds have always been, to be compliant with the Administrative Procedures Act. The judges are the ones that need to make these interpretive decisions, these statutorily determinative decisions, and not the agency. So that's where we are. So I think it's just a matter of who makes the decision ultimately. And the case or the removal of Chevron has kind of pushed it back to the courts.
Let me ask you a general question that we can get into the SEC. So again, not a lawyer. Like, I look at the reactions to Chevron. I think, the people on the right, your friends, got a little bit overly enthusiastic about it. It means, my friends on the left, it's like, oh, the sky is falling, and it's always more complicated. When you look at what's happened in this country and you look at how people characterize the district courts and the circuit courts as kind of more liberal, more conservative, and kind of Amanda referred to this judicial interpretation, even under the major questions doctrine, it seems to me that there's an awful lot of room for interpretation that if it goes to a conservative court, it may kind of, favor to say, well, the agency doesn't have that authority. And if it goes to a liberal court, it says the agency does. So how much clarity is there really coming out of this major questions doctrine? Because it sounds like it's a way of thinking more than a law per se. Am I missing something on this? Anybody? Amanda, Allison, whoever.
Well, Amanda, please. And then
No, I think that it may not matter in a lot of cases, but that it will matter in some cases. There have been some examples in this administration of this is sort of when the major questions doctrine sort of came out, finding in an old statute sort of newfound power to do really big things. And I think that sort of regardless of the disposition of the judges that confront cases like that, this will be a clear instruction to them to say, no, that we're going to interpret the statute not to grant that authority. In most cases aren't like that, though. Most cases involve that have implicated Chevron in the past have involved, interpreting terms these agencies have to do to implement their mandate, and the kind of deference that Tim was referring to, Skidmore deference, which isn't binding in the courts, but instructs courts to give respect and to listen to the sort of learning of the agencies, is still going to be influential. So, it, you know, so I don't think, and the Supreme Court hadn't cited Chevron for 10 years. The lower court sort of cited to support probably the outcome they were going to reach anyway, but it made it easier to reach that outcome. And so now, they'll have to do a little bit more in their reasoning. But
that's helpful. Thanks. Allison, want to jump in?
So, for what it's worth, since you characterize here, the left says this, the right says this. I'm not speaking on behalf of the entire left, but I do lean that way. No surprise. And here's what I'll say. First of all, I think MQD makes sense. It's new and it's sort of nebulous, and we don't know where it's going to take us. But of course, there should be some boundaries around the ways agencies interpret their authority. So to me, the doctrine writ large in theory makes a lot of sense. In practice, both with MQD and the loss of Chevron, I think what you will see is greater tools in the tool belt for judges who are either ideological or potentially judges. It will make it much easier for them to reach whichever outcome they are inclined toward already. So that who knows whose ox will get gored in any given situation, unless or until you get to the Supreme Court, in which we have a pretty good idea of what it will look like, but not otherwise. So I think these changes will make a difference, and they will enable, we'll see what happens over time, more activism from the judiciary, no matter what your ideological bent may be. I also think it's worth noting that in Chevron, that can be overcome by legislation. They can change the language of the APA anytime they want. Who knows whether there'll ever be any sort of effort afoot to do that, but it can be done. And the same is true for MQD. That can be changed by Congress. They can say, oh, we did intend to, or here we hereby bequeath you the authority to do X, Y, Z. So they're important. We'll see how they play out. I think they will allow more judicial activism to the extent that's already in the DNA of certain judges and districts, but they can also be changed over time. And one other potentially interesting point here, and I'm sure most of the folks on this panel know this, but this notion of it was celebrated on the right and decried on the left. You may know with Chevron, it was the other way around. When Chevron was presented, it was the right that was pushing very hard to get that Reagan era interpretation out of the EPA. And so now, and things have changed. So again, you never know whose ox is going to be gored with these. And we'll see going forward. That's reason at some level where I say the First Amendment is what worries me the most, simply because that's constitutional and Congress cannot deal with that. Maybe around the edges, but.
Tim,
I want to just quick say, if you go back and look at the history, you will see those that supported the Chevron decision back in 1984. One of the main arguments was that this was the way to push back on judicial activism.
That's right.
Which is really funny. And you're right. The same people that were opposed to it then are now for it now. It's politics, and I happen to love it. There's a couple of things I did want to say. I know, Allison, you mentioned that it was relatively new, and Bob and I just talked about this. So he was asking, when did this MQD, when did it start? And so I looked at a little bit of research and found that I think the first case that dealt with it was back in '94. So it's new-ish. I guess new when you think about the jurisprudence of the court, it's new, but it's not that terribly new. And I think it was a 2014 case that was maybe the first that specifically said or used the language economic and political significance. So I think it's been applied more. And Amanda, to your point, the court has certainly not used it in 10 or more years, but the courts of appeals certainly have. They've used it quite a bit, and the federal courts have relied on it consistently. I read an article just this morning, again, because Bob always likes me to be prepared for these things, that there was that when petitioners go, or when attorneys go in front and argue their cases in front of the Supreme Court, they go out of their way not to mention Chevron, specifically because they were, in the past 10 years or so, specifically because they were worried that they would kind of get their heads chewed a little bit about it. So it's been the development of Chevron has certainly been an interesting phenomenon to watch. I agree with you, Allison, though, the First Amendment issue, it'll be very interesting to see what the courts, if they address it in the cases or how they address it, because that could be very significant moving forward.
Let me just say, Tim, it's really important that you be prepared, because as the panelists know, I'm never prepared. So, you're prepared. I'm prepared. So before we get to the SEC, any general comments you want to make, Betty, on the major questions doctrine? We're going to talk about what this means, if anything, to the SEC climate disclosure rule and more generally.
Yeah, I thought I would add a few things just because I imagine a lot of the audience are not lawyers, and a lot of this we could kind of geek out on it, but maybe stepping back a little bit, like, why are we talking about this? And it's the Constitution of the United States divides the federal government into three branches. I know this is very easy for everybody, but just to be clear, legislative, executive, and judicial. So we're talking about legislative, which is Congress. Has Congress conferred authority to agencies like the SEC, which are part of the executive branch, to interpret law or interpret policy. And we're talking about the judicial branch, which is the Supreme Court and all of these other courts that we've been talking about here. It is important, though, because if you kind of look at the chronological thread of challenges under the major questions doctrine, the Chevron doctrine case that we've just talked about, and the makeup of the Supreme Court right now, which is more conservative than not, it's looking like it's sort of, a constriction of the regulatory, the administrative state, some would say. But on the other hand, now that we're having these nuanced conversations, there are ways for agencies to continue to do their work properly. And so I think that's really what agencies are looking at now. What are their responses to this, the Chevron doctrine cases? And a lot of it is, I think they're still thinking that they can still, they will still have deference for whatever fact finding that they do. As Tim said, deference under Skidmore, for sure, if there's some sort of highly technical interpretation they need to make. There are ways, actually, that maybe Congress could delegate more to agencies. There's nothing that says Congress can't write a law delegating it to agencies. So that's something to think about. I've definitely heard rumor that maybe next term from the Supreme Court, they might challenge the non-delegation doctrine. But, this is how life goes. You keep rolling with the punches. Things keep changing. I will say from a practical perspective, because Bob, you've asked me to kind of talk about what's happening in the real world and what are my clients doing in corporations. Are they having these academic conversations? What are they thinking about this? And for sure, before the Chevron cases were decided, a lot of highly regulated entities are saying, what does that mean for us? Because there are actually some precedents and some regulation we rely upon, and we really don't want those to be disturbed and challenged. But there may be some that we want to challenge. And if you read the cases from Chevron, you'll see that there's this strong thought of stare decisis. And so if some cases have been decided back in the past, they're not necessarily going to be disturbed at all. So if cases have decided and upheld agency interpretations or regulations under Chevron, those pretty much stay put, which is nice, because really, I think stepping back, why we've been talking for an hour about all of this, it's about regulatory uncertainty. For me, it's about how much certainty can we give businesses to operate properly, whether it's under conflicting, climate change disclosure regulations or laws, or under, changing sort of judicial interpretations of law. So maybe that helps a little bit to tie it up a bit.
So that's helpful. It's very helpful. We have 5 minutes left. And so what I'd like to do, here we are in September. Another thing I've learned from Tim is that Republican courts move slowly. So, and I guess so Democratic courts move quickly, and you could say Republicans move slowly and carefully, and Democratic courts move quickly and, ineffectively or carelessly, or draw your own opinion, however you want, in terms of these courts working. But in September, we don't know what this 8th District Court is going to decide. We talked about the cost-benefit analysis, like looking in your crystal balls, thinking about the Chevron deference being eliminated, the major questions doctrine. What's your predictions of what things are going to look like kind of early next year as companies are preparing their reports? Where do you think we're going to stand with this disclosure rule and kind of how we think about the SEC in general in the light of this broader context? And maybe we'll do this in reverse order, and we'll start with you, Betty, and then go to Amanda and Tim and Allison, and I'll just thank you all, and we'll go do whatever. Start with you, Betty. Your crystal ball.
My crystal ball. Oh boy. Let's see. Let's just break this out. I think, look, companies that can continue to do what they do best, especially the large caps, they have had a very established disclosure controls, internal controls, a control environment. They will continue to take a look at what is required, and the 10K will come first in February for large caps, and some of them will have to file CSRD. They're all looking to try to figure out what to do under California. But I think, as long as they're complying with SEC requirements as they stand today, as well as CSRD, it kind of trickles down from there. So I'm optimistic.
Thank you. Amanda, your crystal ball.
Well, in terms of what companies will do, I defer to Betty, although I would say, obviously, if the Republicans win in November, then, regardless of the outcome of the litigation, of course, the climate disclosure rule is likely to go away. So there's some shoes to drop there. In terms of the litigation, I already indicated that I think the cost-benefit challenge, if I were the judge, I think that would be the easiest way to decide it, because I think both the major questions doctrine challenge and the First Amendment challenge both require sort of asserting that the SEC is being pretextual in the way that it's cast the final rule, because, it does claim that the rule is about financial materiality to investors, and the materiality qualifiers that were added bolster that position. And both of those other arguments suggest that the SEC is doing something else. And I think it's hard for courts to claim that an agency is being disingenuous like that. So, but if you look at financial materiality and then you say, okay, well, that's what's relevant here. Let's look at how the cost benefit analysis, if we're focused on that, shakes out. I think there are some real weaknesses. There's a lot of reference to investor demand, but it's a broad group of investors, not all of whom may have been motivated by financial materiality. It's complicated as well. As we've said, sort of the marginal cost is different in light of these other reporting regimes, but some of those, like whether California's rules are going to survive, is unclear, and they're going to be postponed and they're subject to challenge. So I don't know what's going to happen, but those are my thoughts. It's very interesting.
Thank you very much. Tim, what do you think?
Okay, let's say, well, given that we just don't know what the court will do, of the three challenges that I've talked about here, I'm going to go with, if I have to pick one. Now, they could, of course, decide on more than one. I'm going to go with Allison's MQD. I think that's the one that, just because of where the court has been, with the statements and at least the politics behind it, that's where I think that they come down. I think that they send a strong message to the SEC that they are in fact outside their lane, or at least that's their interpretation. Whether right or wrong, that's where I think the court will come down. Interestingly, though, regarding the First Amendment issue that I know Allison, mentioned, that was one of the challenges to the California. Remember, we talked about this, and I mentioned early on that the simultaneous litigation that's going on at the California, challenging the California climate rule, which I should add, includes Scope 3 and does include private companies. So it is certainly much broader. I certainly, because the issue of the First Amendment issue is argued the same in both, I would be very interested to see how the courts do it. I think ultimately that case gets to the Ninth Circuit, and both of these cases eventually go to the Supreme Court, where I think both are overturned. That's if I'm going to predict something, that would be my prediction going forward. As for companies, I think Betty brought up something regarding the compliance dates. I think that the SEC, now, of course, they've not made any commitment to it, but I think that they're going to have to do at least a day for day extension on the compliance days. And I had an interesting conversation just the other day. If the SEC says, no, we're going to implement something quicker, if the rule survives the legal challenge and goes into effect, I think the SEC would potentially be in violation of the APA again, if they decided to do something short of that. So to Betty's clients or to other clients, my prediction is that the compliance date will be pushed appropriately into the future.
Thanks.
So those are my predictions.
Cool. Allison?
So a couple points, and Amanda raised this, the elephant in the room is the election and what happens, because of course that could change what the SEC does. And if the administration turns over, I think it's almost certainly the case that you'll see a rule And there are a lot of different ways in which they could accomplish that, go away. The SEC's rule, it's a little bit of a be careful what you wish for, because if California's rule survives, what you might see instead is a proliferation. We've got these bills are sort of kicking around in other states as well. And that is a nightmare scenario in many ways. So what we'll see, I think, I still on balance tend to agree with Tim that MQD is the larger threat. But it isn't to say that cost benefit is, neither of the other two arguments are without their strengths, especially in front of this particular Supreme Court. But the key for me is the impact of the findings among those three and how it will impact things going forward. So to me, even MQD, which is potentially quite hamstringing for an agency like the SEC, depending on kind of where they go next, it still can be resolved outside the constitutional boundaries. So again, I can't predict without knowing what happens with the election, because that's such a big unknown and can really change things. One final point, though. What it will not impact is stakeholder and investor demand. And investor demand is not really the defense for costs in the cost benefit analysis. It's true they speak of it a lot in the rule. That's not how they balance the cost. But nevertheless, that's not going anywhere. And businesses have to contend with the wishes of the people with the purse strings. So
let me give my 2 cents. I'm not going to make a prediction because I know less about this than all of you, but I'm thinking about the civics lesson that you gave us, Betty, that there's the 3 branches of government. And that was a useful lesson. Tim and I have talked about this some as well, where what's interesting about it, and I'm kind of a glasses half full guy, even in this polarized environment. I mean, one interpretation of why you have the MQD is that Congress has been lazy in terms of being clear about what it wants agencies to do. And so, if you need clarity at the agency level for what its authority is, then, you can do that through legislation. And to have stable, lasting legislation, it needs to be bipartisan. As all of you know, I've had my GOP outreach campaign for the past couple of years. That's how Tim and I met. That's how we started our responsible business initiative that, Amanda kindly agreed to join the academic advisory board. And over the past year, I've been digging deeply into the climate issues with the so-called eco-right. So there's 6 or 7 organizations, center-right, that are very focused on climate change. And I know pretty much all of them. And I think they're doing great work. And their work is very focused on climate change, some different views than what you would see, kind of left and center left. But they all agree that if you're really going to tackle climate change, where reporting is a part of it, it's an important part, but it's not the only part, you're going to need bipartisan legislation. So my glass is half full guy kind of thinking is if what this leads to is a recognition that we need more bipartisan solutions, through Congress, through legislation, so we can clarify what the rules are. So you've got stable environments, Betty, for the corporate community and the investment community to work in. And I think that'll be a good thing, but it's never simple. And I'm sure there'll be, the sound and the fury around this stuff forever, because that's just like life in America and democracy. And that's a good thing. So with that, let me thank all of my columnists, Allison, Tim, Amanda, Betty. You guys are all superb. Wish you an enjoyable rest of September, and I'll flip it back to Peter and he can introduce the next panel. Take care, everybody.